home and lick my wounds. But I came to a dinner last night with Professor Siegel. Most of you know Professor Siegel, know who he is. He is Mr. CPLR, Mr. New York Practice. Single-handedly, Professor Siegel has had more impact on the New York practice and the CPLR than any one individual in New York State and probably the United States. And it was just fascinating to see another side of Professor Siegel. But what I'd like to tell you is that he is very sensitive to the upstate practitioners. He told us last night that many a times a bill would be presented to the legislature and Professor Siegel would put a hole to it in order to address our concerns. Because he said there's really two parts to the state. There's New York City and there's everything else. And many times something that would be passed for the practitioners in New York City would adversely affect us, and he would step up to protect our rights. So as practitioners, we owe an awful lot of gratitude to Professor Siegel, although we all take his name in vain probably sometimes when we don't agree with what he's done, but I can tell you that he's out there fighting for us. The reason I told you about the dinner, because in reality, Professor Siegel is captivating. He's witty, he's charming, he's personable, and we just had a delightful conversation. He discussed everything to his views on Jackson and to civil procedure. But before we bring Professor Siegel back, I'd like to ask Greg Peterson to stand back up, because you see, not too long ago, it was actually November 15th of 2004, Greg was attending the event at Albany Law School commemorating Justice Jackson. And Professor Siegel, a distinguished professor of Albany Law School, was there in the audience. And Greg Peterson, never one to miss an opportunity, had a conversation with Professor Siegel and asked him to come here to speak. And because of Greg, Professor Siegel's here today. So Professor, if you would please come up. And no, Phil, I won't tell the story about myself in the class with Professor Siegel.
Actually, it was Stan Lundeen, Dale Robbins, Greg Peterson. We went out to enjoy the Albany Law School commemoration of Robert Jackson. It was a delightful evening, and as Professor Siegel was right there, and as we engaged him in conversation, because you want to see the icon of our business, I learned immediately that he had a strong passion for Robert Jackson. And so, again, not losing the opportunity, here we are. And on behalf of the Robert Jackson Center, because we realize it's been a while since you've been out here, and we realize that you're here today, and we don't want to lose the opportunity to give to you this is a lithograph of a portrait of Justice Jackson, which is signed by the portrait artist, Lorene Colburn, and it's a limited edition. And frankly, we've only given out 16 of these to the likes of Chief Justice Rehnquist and others, and we would be honored if you would accept that from us.
Thank you so much.
And with that, we'll turn over the podium to Professor Siegel.
Thanks so much, Greg and Steve. Greg's energy in getting this center operative and moving forward is a prodigious thing to behold. And I'm glad to participate here in this program today. A word about Jackson. That was not just an invented datum for the occasion. Justice Jackson, from the point of view of his style of writing, is my favorite judge. I have told this to classes year in and year out. He had a way of throwing a thought into your head so thoroughly that you didn't stop to realize that it was mere language that was putting it there. And that directness of expression is something I've always envied and tried to emulate. I may have said a few habits that he probably wouldn't approve of. I use contractions, isn't, aren't, and whatnot, so it's a little less formal.
You do a little bit louder. I'm going to make it closer.
Essentially, okay? Essentially, his writing style is the thing that impresses me most. I was just saying at the dinner last night, there are a number of judges. When I started reading law, you didn't notice who the judge was. The name wasn't meaningful to you. But as you started to read through the opinion, every now and then you would stop and ask yourself, who's writing this? Because the style was so distinctive. Jackson was one of those. Cardozo was one of those. Learned Hand was one of those. Arnold Holmes was one of those and whatnot. There's a very small coterie of great stylists in the law, and Jackson, for my part, was the most direct, because I think I've always tried in all of my writings to be as direct as possible, as simple as possible. If there is a 3-syllable word and a 1-syllable word that means the same thing, I will use the 1-syllable word. If I can use a contraction, I'll use a contraction, because that's the way we talk, and when you read it that way, I think it comes across a little more comfortably, a little more familiarly. Now, for the materials today, you've been given the materials, how many items are there? 99 or 98? 98 items. This is civil procedure. These are 98 new items from last year. It's an annual thing I do. And there are 98 new items on the list. 98 items I think worthy of calling to the attention of the bar. I do it, of course, in my practice review. Siegel's practice review, I do it in the New York State Law Digest, in the textbook and whatnot, in various forms. And in these updates, I call out the most significant developments and put them down. This year, I could have had 200. That's the way civil procedure is. Cut it back to 98 or so, no, 98. And put them down in chronological order. Things that affect civil practice, your civil practice. The chronological order of the CPLR. So that as you go through the thing, if you know what the sequences of the CPLR at all, you find the materials set forth in that same sequence. And so that if you go through the materials, you read the banner or the headline, whatnot, you might just remember there was something about it at the seminar and thumb through it and get to it pretty quickly at its particular juncture. But for the oral presentation today, our talk, I have an entirely different sequence. I write down things in order of importance, at least to my mind, things that are most important to get across. And I'll take you with me through that. I'll tell you exactly what item I'm dealing with. The pagination is somewhat different from what I submitted, but I'll just go with the item number, which is the same. Okay, and let me please ask you this. I love it informal. I am the quintessentially informal man. I try to be. So as we go along, you got any questions? Put them. It's always more fun when we're going along, you put some kind of question. Don't worry about somebody trying to monopolize the topic. I've been in this business for 43 years. I have cures for that. I can perform magic before your eyes. I can take an absolutely useless question and turn it into something of great value to you. So don't worry about that. Please feel free to talk without any self-consciousness about it. I don't like these seminars when they had written questions submitted at the end, and while they're talking, you see the written questions coming up to the dais, and the person to whom the question is submitted is frantically spending the rest of his time up there, preparing there. It all comes off so stale, rigid, sterile. That's the word. And I prefer the informality of it. You know, every now when I get caught, I make a mistake periodically. Fine, it's the greatest thing to find a professor in a mistake also. But when it happens in class, it's a cause for celebration. We got him again. There you go. So don't hesitate to pitch in. Okay, now, as far as materials are concerned, I'm sorry, I was going to distribute my practice review. The latest issue is issue 161 of my practice review. It's a monthly newsletter I do. I had it prepared with sufficient numbers here, with a packet of subscription materials about them. I forgot to bring them. So what the law school is going to do when I get back, we're going to keep the names of all of you who are here, maybe the whole Bar Association. We'll ship those things out. The copy of the current practice review and this little packet of subscription materials for the review. 161 has as a lead note something I'd like to lead off with, though it's not part of the written materials. And as I do these things, you are able to tell me what's current and what's meaty up here vis-a-vis the rest of the state. Now, if I say to you HIPAA, H-I-P-A-A, has that been making you trouble?
Sure.
Good. I'm glad not that I want you to have trouble. I just want to know that you're in the same situation the rest of the state is. This is driving all the judges crazy. And this has to do with a personal injury action, and the treating physician is in the picture, and the note of issue has been filed. This is all post-note of issue phenomenon. And the defendant wants to interview informally, ex parte, alone, the plaintiff's treating physician. Now, this was done on a regular basis, but now because of HIPAA, which is a federal act designed to preserve privacy, some courts have construed HIPAA as interposing certain procedural requirements before the defendant can interview the doctor. And courts are all over the place in the construction. Some courts say there's no change, you can still do it. Others say, no, you need an authorization from the plaintiff for a post-note of issue interview with the physician. You have to get that, and if the plaintiff won't give it, you got to go for a court order and all this. And the lead note in number 161 discusses that, built around a couple of cases. And soon had I finished that, and that was published, I got another one, another couple, that I'm going to make, not a lead note, a big note in the issue 162, which will be the next issue of the thing, about this HIPAA business, which has become quite important all around the state. So I just call that to your attention. Now it would have been convenient to have that 161 in front of you, but you'll get it in due course anyway. Okay, now that is the extrinsic item I wanted to inject. The rest I'll do now from the materials, and I'm going to start towards the end with number 85. Sorry, I can't tell you the pages now because your pages are not the same as mine. My page is 26. What's yours? 27. What's this? Okay, a little simple matter. In the course of writing over all these years, I learned something early. Quite often you see a very liberal case come down. I'm an advocate of liberal construction of civil procedure. Let it be subordinate to the substantive ends, liberal construction. And then I will find periodic construction so liberal, I said, well, that's great, but I worry that other judges are not going to feel the same way, and that if somebody who does a research and finds this case is going to read too much into it and get into deep trouble. Now, one such case involved a dismissal for neglect to prosecute, which requires the defendant, before he can make the motion, to serve on the plaintiff a demand, requiring the plaintiff to put the case on the calendar within 90 days, and the thing is ended. That demand must be served before the motion can be made. The demand is required to be served according to the statute, which is 3216, by either certified or registered mail. The defendant took it unto himself to serve it by Federal Express. And the Federal Express got them. You'd get there maybe faster than the certified mail would. And when the plaintiff alleged that the service was no good, the court sustained it and said it's just as good, it's an overnight service, and it's just as effective as certified or registered mail, and the court accepted it. And I reported that case. And I reported that case with my usual skull and crossbones next to it. Watch out. Don't take this as an invitation to vary a statutory instruction on service. A simple rule: if a statute tells you to make service in a particular way, do it. Don't vary it. And sure enough, I have corroborative cases afterwards showing the danger of following that instruction. This has to do with a demand for arbitration. Something serves like process. It's got to be done within a very rigid particular time. The statute says served by registered or certified mail. This party served it by Federal Express instead, and the court rejected it. So those who would have taken that earlier case as a precedent for using Federal Express whenever they wish, instead of registered certified mail or some other statutory instruction, gets in deep trouble because of it. So that's the little point made in number 85. If a statute prescribes a method of service, use it. Don't vary it. Okay. Now, that was number 85, as I've said. And the next one I have is number 92 on page, I can't tell you the page, probably 28 yours, huh? 30?
29.
Okay. Interesting. 92 and 94 are set. One case going this way and one case going that way. Diametrically opposed directions. A legal malpractice action. There are more of them out there than you realize. You go by the reported cases, if you count by the reported cases, which are best evidence of legal malpractice actions, you don't find all that many because the legal malpractice insurers make it a point whenever possible to settle the thing. The last thing they want to see is their client, the legally malpracticing lawyer, so accused, standing in the courtroom with the client suing him and the jury watching the client versus the lawyer. It's not a good situation for the lawyer, and the insurance companies are pretty prone to settle if they possibly can. If the thing does go through and a judgment is rendered for malpractice, well, what does it consist of? Quite often, and we'll use this example, quite often the malpractice consists of the lawyers letting the plaintiff's claim lapse. Not suing on time, barred by the statute of limitations, failure to serve a notice of claim, dismissed for that reason, and that generates the malpractice action. Now the client sues the former lawyer, and actually in that scenario when it takes place, and there are plenty of reported cases, there are two trials in one. The first thing tried is whether the lawyer was guilty of malpractice. And if that's determined in the affirmative, yes, then they try the underlying action that the lawyer should have brought on time for the client, and they try the thing just as if it were the same case, except that the original defendant is not there. And proof is put in through other sources. Maybe he'd be called as a witness. And the judgment is rendered. And if the jury finds that had the action been brought on time, it would have succeeded, the jury renders a judgment in behalf of the client against the lawyer for the sum that would have been recovered against the original defendant had the action been brought properly. A full judgment. The nice question that creates this conflict between these two cases is, to what extent may the client get that judgment enforced against the lawyer? Suppose, for example, it's $1 million judgment. That's how much would have been recovered against the defendant, had the defendant been sued, the original defendant had been sued in time. How much can be recovered? Is the plaintiff automatically entitled to recover the entirety of the $1 million? The answer is no. He's only entitled to recover whatever could have been recovered, forced, against the original defendant. So the big issue injected is how much could have been collected on the judgment. These two cases inject the point of departure on the matter of who has the burden of proof on that issue. One says the client must prove that he could have recovered that money against the defendant. The other says no, the lawyer has to prove that he couldn't have recovered that money against the original defendant. That two appellate division cases, sure, second and first departments, differing on the very point. Okay, what a lesson! You like to draw lessons from this thing. Well, I can suggest one overriding lesson: try not to be guilty of malpractice. And I want you to mark that down and say you heard it here first. Okay? Stay away from these things, because these very sticky problems arise afterwards. The Fourth Department had an entry on this thing too. I forget which side it came down, but it's definitely a Fourth Department case on this point as well. Okay, that's number 92 and 94. Questions? Anytime. 93. Okay, so often the point of this case can be made quickly, but without background it doesn't come across meaningfully. So I like a little background on this stuff. That's another one of my habits. Tort actions all over the place, personal injury actions. When a plaintiff brings a personal injury action against a defendant, serves a summons, a complaint on the defendant turns a summons, a complaint over to the insurance company, which supplies the lawyer, undertakes the defense and whatnot. Now, sometimes the insurance company disclaims. There's no policy, the policy wasn't paid for, you didn't give notice in time, delay and stuff like that. They disclaim. What happens now with respect to the plaintiff's claim against the insured and the insured's right of defense? What happens? It's all up in the air. The point about whether or not the insurer has to defend is disputed. The insurer says it doesn't have to defend. Disclaim. The insured says the disclaimer is no good. But you do have to defend. It's a dilemma on all sides. To resolve the dilemma, the matter has to be adjudicated. Now, a long time ago, what the defendant would try to do when it's insured didn't defend, would implead the insurer. The Court of Appeals precludes that. The insurance company may not be impleaded even if it disclaims. So what evolved was the practice of having a separate declaratory judgment action brought while the the tort action pens. A separate action is brought, the tort actions are suspended for a while, and the insured brings a declaratory judgment action against the insurer to determine the validity of the disclaimer. Or the insurer brings a declaratory judgment action against the insured. Either can bring it against the other to determine the validity of the disclaimer. And when that's adjudicated, then the parties know their rights. Suppose the insurer does not bring it against the insured, and the insured does not bring it against the insurer. We now have perhaps the most interested person of all standing off on the sidelines watching this and in a dilemma herself. She's the plaintiff, the injured person. She wants the coverage there, and she doesn't see either of the insured or insurer bringing the test. What would happen is the plaintiff himself, would bring the declaratory judgment action for a determination of whether the insurance company applies. I thought it was a very good idea. A number of courts thought it was a good idea. The Court of Appeals thinks it's a bad idea. And the result is this case holding that the injured person does not have the standing or authority to bring the declaratory judgment action against the insured and the insurer for a determination of the disclaimer. If you represented a plaintiff, an injured person, what would you do? I mean, it would be nice to bring the disclaimer. You know, that, I don't know, is this insured solvent? Am I wasting my time pursuing this thing if there's no insurance in the picture? I want to know if the insurance is here too. What I suggest is contact the defendant and offer to bring the declaratory judgment action in that person's behalf, or to subsidize it, to encourage that the thing be brought. By the way, if you represent an insurance company in that situation, may I suggest you are on the weakest ground of all in not getting that disclaimer tested. Because what's going to happen then is the plaintiff will proceed against the insured, may get a default judgment for a huge sum, and afterwards, now the plaintiff can sue your client, the insurer, on the judgment. That's permitted. Post-judgment, the suit is allowed. And you're in a very bad bind now. You may defend that action by proving the disclaimer, and the disclaimer was good. But you better win on that point. Because if you lose on that point, and the court determines no, the disclaimer is no good, the policy is in effect, you are now confronted with a judgment by default or otherwise for a large sum of money that you have forfeited the right to contest on the merits. A very substantial forfeiture by the insurance company. So it always surprises me when the insurance company just sits back and lets somebody else worry about these things. I think the insurer has a dilemma there too. Well, in any event, the Court of Appeals says the injured person cannot bring the declaratory judgment action, the definitive ruling on that point, number 93. Number 91. Take a drink for this. This has to do with these recent rules about lawyer-client relationships. First of all, you know about the requirement of the letter of engagement. You must furnish a letter of engagement to every potential client. You don't have to if it's under what? What's the figure? $3,000? Or if it's over something, 50? Whatever. Give the letter of engagement. The letter of engagement is really across the board. How do you know it's going to be for less than $3,000? How are you going to guess that? Give the letter of engagement. A simple letter saying, this is the way the fees work. We charge this much for the this kind of effort charged by the hour, and you satisfy the thing that way. I ask you a nice question. Suppose you don't furnish a letter of engagement when you should have it. You now sue the client for the fee. The client disputes the fee, and you wish to sue the client for the fee. You never furnish a letter of engagement. What impact does that have? Does it mean you forfeit the fee? You can't recover on it? Simple question. Simple answer. The answer is yes. Cases have held that you forfeit the fee by failing to have furnished a letter of engagement. So it's an extremely important matter. While I'm on this subject, whenever I talk about the letter of engagement, I also want to suggest to you something known as the letter of non-engagement. I had a case. I didn't have a case. I know of a case in Minnesota or Wisconsin, the upper Midwest, 10, 20 years ago, which opened my eyes to a possibility that could affect New York as well. So I immediately wrote it up in the New York State Law Digest, or my practice review, whichever it was at the time. Look at the case. Interesting case over there in Minnesota. The plaintiff thought she had a medical malpractice action against the physician. The attorneys that she went to said she did not, that it wasn't meritorious, and they would not bring it, and the statute of limitations lapsed and all that. A while later, after the statute of limitations had lapsed and the thing altogether, she's at a libation of some kind. There's another lawyer there, and she just volunteers the stuff of her case to the other lawyer, and the other lawyer says, Siegel, you didn't have a malpractice claim? Oh, I think there's a viable malpractice claim there. So she asked him if he would bring a malpractice claim against the lawyer for the failure to bring the malpractice claim against the doctor for saying that the claim had no merit. He did in her behalf, and the doctor, the defendant lawyers were found to have been guilty of malpractice because the claim was meritorious. They tried the underlying claim. I think it was $650,000 or $700,000 involved, and that's how much the judgment was for. But the defense was, look, we never were engaged by this. The client came in. It wasn't the client, just a visitor. We said, no, we're not interested in the case. We don't think it has merit. That was held to have been an act of malpractice, and that cost them something like $700,000 to giving that advice. So, looking at this thing and asking myself, what about New York? Same thing could happen in New York, possibly. What advice? The advice is the letter of non-engagement. If somebody comes into your office whom you don't wish to represent, you don't think the case is meritorious or whatnot, don't tell the client the case is not meritorious. Don't make that judgment. Just say, you may have a viable claim here, but this is not up our alley. We don't entertain things like this. We don't care to do that. We suggest that if you really wish to pursue this matter, you consult another lawyer promptly. There may be statute of limitations issues, time elements. Just advice to that effect. Put it in writing and furnish that letter of non-engagement to that person, and you protect your interest. I then put the question, would you recommend the lawyer to whom this person might refer? I wouldn't. Because of that, if you recommend that lawyer and that lawyer doesn't do the job, maybe they find you to be the surety for that performance. Just say, we can't handle this. There may be a viable claim here. We don't presume to reflect on that, or you suggest you get in touch with another lawyer promptly, because there may be statute of limitations issues and you cover yourself that way. As a matter of fact, there are a couple of legal works on malpractice, legal malpractice, that have a form of letter of non-engagement in it. It's another good thing to think about. Right, that was number 91. No, it wasn't. I'm not even at 91 yet. That was background to 91. This business of the requirement of the letter of engagement is matched by another requirement, enacted almost concurrently. Rule 137. Once again, concerning a fee dispute with a client. Now, I don't want to inject something here which is not a problem here. Does it happen every now and then that you have a dispute with a client over a fee? This is one of those peaceful areas that never has any kind of problem. So you do have occasionally a problem with the client and the fee. Whenever you've got a problem, and I assume you gave a letter, whenever you have a problem about the fee, and you wish to pursue your rights at law, you must, I assume you know this, you must give the client notice of this dispute and that your intention to pursue your rights to collect the fee, and you must give the client the option. You have to give the client the option of choosing either arbitration or litigation. The client has that choice, and you are bound by whatever the client's choice is. Suppose you don't give that notice, and you just bring an action in court without having given that notice. Cases hold, there's another. Cases hold that you forfeit the right to sue for the fee in court by not having given notice of the option to arbitrate instead. Now, another aspect of this rule, which is quite involved, Rule 137, is that if it does go to arbitration and substantial legal issues are raised, including a claim of legal malpractice, which is sometimes almost automatic in these cases, a defense of legal malpractice, the statute says that the thing ceases to remain in arbitration and goes to court anyway. So here's one lawyer brought an action in court without giving the notice of the option to arbitrate. And in the court action, the client actually interposed the defense of malpractice. Now the client moves to dismiss the action because the client was not given notice of the option to arbitrate. The lawyer countered very logically that, look, if we had gone to arbitration, this defense of malpractice would have pushed it off into court anyway, so here we are in court, let's stay here. The judge didn't buy the argument. The judge dismissed and remitted the lawyer to give the notice of the option. The court held, perhaps unrealistically, that it's not entirely academic, because perhaps if the lawyer had given the client the option to arbitrate and the client had exercised the option and gone to arbitration, perhaps the client would not have interposed the defense of malpractice in the arbitration context. That seems to me a little hard to buy, but that was the theory. In any event, you're involved with a dispute with the client. Notify the client of the client's right to litigate or arbitrate. Let them make the choice. And make the choice, and you proceed to arbitration litigation accordingly. That's the situation. How can you be divested of your right to litigate? Are you not a person? Are you not a citizen? Are you not entitled to rely on the Constitution of the state of New York, which says that there is a right to trial by jury in all money actions, according to common law in that regard, constitutional right now? How can I divest you of your right to litigate and to try by jury your money claim against a defendant? What's the answer to that? There's an answer. The answer is that this arbitration, you have to go to arbitration, but the result is not binding on you. If you don't like the result, you can ignore it and go to litigation as if there never was an arbitration and enjoy what the statute calls a de novo trial. Now, if the lawyer has the option of disregarding the award altogether and going to litigation, what is the whole effect of the arbitration? That's been asked many times. The fact is that there was a precedent for this kind of thing in earlier procedures as well, and it was found that despite the technical availability of the de novo right, it wasn't used that often. And statistically, the arbitration thing was workable and proved to be an effective device, and that's what now grounds the 137 as well. You have the de novo trial right. If you don't like the arbitration award, but you may find that the arbitration award is close enough to be acceptable, so you don't want to bother litigating. That was number 91 on materials. Nobody's talking to me. It's very lonely up here. You know, if it comes to worst, I'll start asking questions. All right. Okay. Oh, this was a southwestern New York phenomenon. I'm delighted to report it to you. This was this case over in, was it Steuben? Was it Steuben County? The number 10, the peace case? The timestamp? Now, when you say timestamp, isn't that like a religious phenomenon in litigation? You take a paper in, it's got to be served on time, filed on time. My God, the timestamp is, you take the timestamp back and you put it into the safe, don't you? You're close to it. But what is the effect of this timestamp, the clerk's timestamp? Very rarely does it pose any problem. You take the papers in, the clerk stamps them with the time, and now you know that were filed as of this time, and measured by the statute of limitations or any other time limit, you're on time. Suppose, however, that you bring the papers in on time, within the limit, and the clerk does not mosey around to stamping it until a few days later. which is beyond time. Now what? This came to a big argument over there in this peace case. Apparently everything depended on whether the papers were filed on time, and the clerk's date stamp said they weren't. The party insisted, we filed these papers on time. The fact that the clerk stamped them 3 days later is not our fault. What governs? What governs is, you'll be pleased to know, the truth governs. Whatever the truth is, but you've got a contest on your hands. And the date stamp is a difficult thing to overturn. But with a sufficiently energetic proof, you can overturn the date stamp thing and prove that you filed the papers on time, and the clerk still there is responsible for this thing, which you are not responsible for. The plaintiff was able to, I forget the plaintiff, whichever party was filing, was able to prove this. And some very helpful item of proof was the testimony of a former deputy clerk who was fired and disgruntled. And that proof, with other proof there, the court said the date stamp is wrong. The time of the actual filing was this, and the whole procedure was sustained. So the good news there is that date stamp in the clerk's office, while certainly having certain ecclesiastical elements connected with it, is not really the be-all and end-all.
Question, Professor Siegel,
Yeah.
is it necessary that it actually be filed in the office? This is a small county. You might meet the county clerk at a restaurant, or might see the county clerk. The office is closed, the day is the end.
All right, and I got to ask you something here. Listen, how close are you to the edge of the statute of limitations on this thing?
It's the last day.
Why do you do that?
Well, the fine came in 3 weeks before, and you know.
But then you had 3 weeks? I'm always asking these questions. You wait, it's only when you wait till the last minute that this becomes a problem. So now we have to meet it. And frankly, I don't know what the answer is to your question, but I'm anxious to see what I've got to say about it. So let me work this. It's the last day. You're on the last day. You know you got to get to court. Would you be comfortable giving it to the clerk at some kind of a barroom scene or in a barroom? I would certainly want to do it in court. Now, is this the clerk or the clerk?
Correct.
If the clerk says, I'll accept it, and it comes to an argument, I suspect you'll win. But you might sweat great quantities of perspiration waiting.
What about a situation like in this county where the clerk maintains an account for us, and I give it to the clerk, I don't give the filing fee to the clerk, but she has funds in our firm account.
You don't put a filing fee with it?
She keeps the money for us and just takes it out when we need it.
Make sure she does it. I mean, this is the county, this is the department of the famous Menden Ponds case. I don't strike the fear of God. Your reaction has been extremely neutral. This is up in Monroe County. The last day of the statute of limitations was a special proceeding. This famous case went to the Court of Appeals. The petitioner delivered the summons, the petition, a notice of petition to the county clerk, and paid the fee. But the county clerk didn't take the papers and file them. Instead, the county clerk directed, these papers are filed over there with the Supreme Court clerk, not the clerk that does the work. The county clerk is a money collector. And that's what the plaintiff did. The defendant moved to dismiss because the papers were not left with the county clerk. The trial judge up there, what county? Just south of Monroe. Genesee County, what thing?
Livingston.
Was it Livingston County? Thank you. See, you do know about it when forced to admit it. Livingston County, and the appellate division affirmed, the Court of Appeals affirmed, the failure of the county clerk to accept and file the papers, though the fee was paid, is a jurisdictional defect, mandating a dismissal, too late to start over under the statute of limitations. A gross travesty of justice, but that's the law. And it shows you the rigidity of the Court of Appeals attitude in this filing system. And therefore, anything around the time of the filing and the last day of the statute of limitations is a bad time to experiment. Now, in your case, you have a variation. You tendered the fee, you didn't tender the fee. There's money on deposit there. I wouldn't be comfortable with that at all. I tell you what would happen. I have a little more liberal view of civil procedure. I would say, in this case, I would sustain the thing. The clerk took it, the clerk would take the money out of your account, which is a standing account, I'd sustain it. I would almost certainly get reversed by the appellate division.
Thank you.
And you just can't guess what a given judge is going to do, or what the appellate court is going to do in reviewing it. Whose phone is that? You lose all credit for these 2 hours of seeing yeah, that's my response. It's just a dangerous thing to fool around with. If you're that close to the edge of the statute of limitations. Well, yes, sir.
Would you be able to sustain an action against the clerk for negligence?
That's another big question.
I mean, if they gave you advice that was incorrect and
Let's make it
not in
simple.
compliance with the statute you relied on.
Let's make it simple. You filed with the clerk, and the clerk never got around. You presented, you tendered the papers to the clerk didn't file them. The statute says that your tender of the papers is the key moment, and not when the clerk actually files them. So that's a reassurance there. And now, in what instance would you want to sue the clerk because of something that the clerk did? If the tender thing satisfies the requirement altogether, what would be the scenario?
Well, the scenario is that if the clerk accepted this and didn't file it, and the case was dismissed, and the case where we just talked about here, where the clerk said, this is not the place to file this summons, take it up to the Supreme Court clerk. You follow her instructions or his instructions. You take it up to the Supreme Court.
Yeah.
A month later, they tell you that the statute's run and that
That was bad advice.
You're dead in the water.
You might try to sue the clerk. You might try to sue the clerk. And then you have other questions coming in. Is the clerk the agent of the county or the state?
State.
See, and then you have to, if it's a state thing, you got to sue in the Court of Claims. If it's a county thing, you sue in the county itself.
The clerk is a county employee.
Whichever one it is.
Yeah.
I am deferring on that. I'm asking whichever it is, you have to bring that kind of
Probably have to
action.
sue both of them.
The clerk is not immune from suit for this kind of thing, but it's exceedingly impractical to be pursuing. There's something else that's crossing my mind now about clerks. Nassau County had a problem for years, a delay of months before they got around to filing papers. And yet I didn't see one case come out there contesting the issue in any given instance. You know where it could be a problem, and all I'm going to do is state the problem, and I can tell you now, as I stated, I'm not sure what the answer is. You file a judgment. When you file a judgment, the county clerk is required to docket it in the alphabetical books. The docketing in the alphabetical books is what makes it a lien on real property. You file the judgment, the county clerk is supposed to docket it, doesn't. Comes along some other creditor, and as a result acquires priority in the real property. I think if that's the case, you would have a claim against the county clerk for not doing that. But as I say, I'm not sure what the answer would be. Yes, sir.
What's happening in Erie County? We were watching television newscasts saying that they were 3 or 4 weeks behind in filing their papers because of the budget crisis. How are papers getting pushed onto the court calendar? What were they doing with statute of limitations issues? You see the TV shows, and the clerks have piles and piles of papers that they haven't dealt with.
Is that what's happening in Erie County now?
Correct.
Yeah. Well, you tender the papers. If you tendered them, you have satisfied your obligation. I'm talking about filing papers in time and bringing an action in time. When it comes to the docketing for the judgment lien, I'm not sure the law is the same. I just can't say. What is Erie doing to catch up with the problem?
Thinking about it.
Actually, what I heard was that they're filing them immediately, what the piles of papers that you see on the news are, and the ones that have been filed and haven't been put in the drawer. So the problem will be we need a copy of one of those later, of the sorts of piles and piles and rooms of paper, but they do file them immediately. I think that's the one thing.
You see how things differ from one county to another here? Adjoining counties. Cattaraugus adjoins Erie, doesn't it? Yeah. Adjoining counties, the difference. Imagine when you start to go a little distance away, how it differs. And when they ask, well, what do I do in a case like this? Find out what they want done locally and do it. Call the clerk. If in doubt, call the clerk. And do what the clerk wants. Now the trouble is that even do what the clerk wants, you may find yourself too late. I don't think so. I'd like to see whether As a result of this pile of delay there, any case comes down against the county clerk, faulting the county clerk and holding the county clerk liable for whatever the delay is. I haven't seen a case like that, and I'm just wondering if there'll be one. I suspect that they'll resolve this thing and there won't be such a thing. And as far as timeliness of filing is concerned, you've got to remember the tremendous benefit the statute gives you if you're the plaintiff. Tender the papers. And if they're tendered, even if the clerk doesn't take them, if they were tendered. There was a case a couple of years ago, crazy, last-minuteism, a case called Soto. You may have seen the case. I had it in my practice review if you're subscribers to that thing. And I have it in my textbook too in the supplement. The last day of the statute of limitations. There is a large segment of the bar which sincerely believes that the last day of the statute of limitations is the earliest permissible time for suit. I have so many cases of the last day thing. It is the last day. To make it more, this is a reported case. To make it more dramatic, it is the last hour of the last day. At about 4 o'clock, this firm, last day, sends this fellow down to file papers with the New York Supreme Court clerk to start an action. The clerk says, over here, the papers are good, someone's complained and all this, but we require a cover sheet. And you have to fill out the cover sheet with just a couple of statistics. You fill it out, you put it on top. No problem. But the fellow they sent down at the last hour of the last day couldn't see. He was partially blind. And he would have been glad to fill out the paper, but he couldn't see it. He had to go, would you help me? You don't ask a clerk's office to help you at 4 o'clock on a Friday afternoon. They said no. And didn't this thing go to dismissal and a motion to vacate and an appeal finally filtered into the hands of a sane judge, Stanley Sklar over New York County, and said, look, you can require, if you wish, as a local practice, a cover sheet, but you can't turn it into a jurisdictional obligation. The statute and jurisdiction was satisfied when the papers that the CPLR calls for, summons and complaint, were tendered and sustained the service. You see how you get involved? Another case, they pay the fee with a check. How do you pay your fees locally? Check? Well, you have accounts? Both?
Both.
Ever do it in cash?
Okay.
Yes. See, all this stuff, I'm hearing it all. Paid by check. Now, may I suggest that if you pay by check, that it be a good check? I'm just filled with advice here, no? On a lovely Thursday morning. The check bounced.
Oh.
The court held that the filing did not take place because the filing requires a fee, and the fee is not deemed paid if the check tendered for it bounces. I brought that case to the attention of the Advisory Committee on Civil Practice that I've been a member of for close to 30 years. I just brought up, I was very surprised how very upset they were. Because sometimes you pay by check and the money's not in the account, or the bank has shifted it to the wrong place, it's an error. To know that they think that it's a fatality, they very much object to it. It's still under consideration what kind of remedy for a bounced check. New York County does it very well. New York County is, in this regard, is quite sane. It says if it's a bounce check, we notify the bouncee, the one who gave us a bounce check, and we say make it good quick, and they make it good quick, and if they do, everything's fine. But this other place, I forget which county it was, held that it's a jurisdictional defect. I think it was the appellate division, as a matter of fact. So don't wait till the last minute. The only one who benefits when you're waiting, two people benefit when you're waiting till the last minute: the defendant and me. Because I get all kinds of fun writing about this stuff and being immune myself from the thing and just calling the shot. Don't cater to me in this regard. So which one was that now? That was peace. Number 10? Yeah. Number 11. Right underneath, what's this? This has been a problem. This is a Fourth Department case, so a double interest to you. When you commence a special proceeding, you see, you commence an action. You file the summons and complaint, you've got 120 days in which to serve it, and it's pretty clear what your obligations are. The special proceeding is a little more complicated. Now, the initiatory papers in the special proceeding are the petition and the notice of petition, the latter being the process. What you had to do, this was under the statute, to commence a special proceeding, you had to tender the petition and notice of petition to the clerk and do it within the requisite time. You then had a 15-day period in which to make service. It's much shorter than the 120 days. Ordinarily, it's much shorter than 120 days in an action. They brought the papers up there. Now, unlike an action, which merely says the defendant has to answer within a certain number of days, with a special proceeding, you have to set a specific return date, like a motion. Now, you set a specific return date, you know you have to give the requisite notice. The statute provides how many days it is, 8, 13, whatever the dates are, Article 4. And you set it far enough in the future to satisfy the notice requirements. But you may also be a little bit queasy about it because you've got to make sure it's a day when the judge who gets the case is hearing proceedings. A motion day or something like that. This plaintiff, this petitioner in this case, realizing that you can't really determine with finality what the day is going to be until the judge gets assigned and approves the date, filed the papers and kept the return date blank with a little notice on top, a very intelligent little notice saying, we're not sure what the return date will be until the judge is assigned. As soon as the judge is assigned and makes that determination, you will be advised. What a thoughtful practice. And the Fourth Department sustained it. But 3-2. 2 judges dissented and would not have accepted that as satisfactory. So what's the advice? What do you do with your special proceedings? Do you include a day, automatically include a day even if you're not certain the judge will approve it? Always include a day? I see some nods. That's the thing to do. Give the notice you have to by statute, set the return date satisfactory to the notice requirements, and if the judge wants to change it, let the judge change it. But keep a date in there. In other cases, in other departments, holding that the failure to include a return date is a jurisdictional defect. That's the kind of problem you get with special proceeding. Okay, number 11. Once again, commencement. You know you have 2 different options to commence an action in New York. You can commence the action by summons and complaint served together, which is known as the good way to commence an action. And the alternative is you can serve a summons instead of a complaint, a little tiny notice under 305B of the CPLR, which can be just a few words to describe the claim. Just a few words. If you use a summons and little demand, the defendant just has to serve on you a demand for the copy of the complaint, and now you are under the pressure to get the complaint done. When you serve the summons and complaint together, you are in the driver's seat. The defendant is under an obligation to serve an answer. Much more difficult and demanding than serving a little demand for a copy of the complaint. So my suggestion is always serve the summons and complaint together. Don't use 305B, a little abbreviated notice, unless it's a collection case or something where you're really expecting a default. Use the summons and complaint together, not the little summons and notice. I'm not going to ask you how many use the summons and notice. I'm not going to ask you to make that dangerous admission here before all your colleagues. Further reasons. When you serve the summons and complaint together, you put pressure on the defendant. May I ask you here your local practice? If you've issued a summons and complaint and it's gone to a process server and the process server has served it and returned an affidavit of service to you, put it in the file, what's the next thing you hear with respect to that case? What is the next thing you hear, literally, with respect to that case?
Request for an extension.
Yes. May I precede that by saying a ringing telephone? That's it's automatic. The defendant calls up for an extension of time. Now, I imagine you certainly want to be courteous. Courtesy is upstate. Courtesy is expected. You always give an extension of time? Let me make a suggestion. Don't be too generous. Use this as an opportunity to schmooze with the defendant. You want an extension of time? How long do you want? Can you give me an extra 30 days? No, it's 30 days. Certainly, but we have a policy in this office that whenever we give an extension of time, we insist that the defendant in the same extension waive any jurisdictional objections. I don't want to be giving you an extension of time and then see you making a motion to dismiss for lack of jurisdiction, service of process, something like that. You agree to waive it, and the defendant may then and there agree to waive it, and you, in return for your extension of time, have the mutuous gift of a waiver of jurisdictional objections. Great thing to do when you're in the driveway. Suppose the defendant says, I won't give you that waiver. I won't give you that extension. Your answer is due on Tuesday. If it's not there on Tuesday, you're applying for a default on Wednesday. What you're doing is also educating the defendant that you're aware of what your rights are. You're aware of the possibilities are, and you're not going to be lulled into some kind of a situation where they make a belated motion to dismiss for lack of jurisdiction. Just advise the defendant that the honest told. So that's what happens when you use a summons a complaint. Now, I've always suggested that plaintiff's lawyers exact a jurisdictional waiver as a condition for an extension of time. Simple thing. But all I've ever suggested was a waiver of jurisdictional objections. Some defendants, also following this advice, have gone a little further. In this case, went to the Court of Appeal. This defendant, in conjunction with getting an extension of time to plead, interposed its own waiver. The defendant waived all defenses. Did you analyze that phrase? Waived all defenses. This is a Court of Appeals case. After having waived all defenses, the defendant wanted to move to dismiss on the grounds of the statute of limitations. But that's a defense. It was waived. The defense, I never realized I was waiving this. When Appellate Division Court of Appeals, the Court of Appeals said, you waived it. So I never suggested that you waive all defenses. If you're willing to waive all defenses, I think you might consider stipulating to summary judgment for the other side. That'd be a short and get rid of everything. No, just the jurisdictional objection. Another irony about using the summons and complaint together versus the summons and little notice. If the little notice, whatever it is too little, and the court finds it's an inadequate notice, the action must be dismissed. There's no jurisdiction to entertain an amendment to the notice. If, on the other hand, you use a complaint, and the complaint is for some reason defective, you can amend the complaint and preserve it as of the time the original complaint was deemed interposed. That's the other advantage of it. So that as long as it's a complaint, it can be amended. If it's a notice and it's defective, it can't be. So instead of using a notice, use a complaint. When I've said that to audiences over the years, I've had all kinds of wonderful responses. So, Professor, you get out of the last minute, you can't draft a complaint. I reject that, out of hand. Just like that. I said, oh, don't tell me that. Maybe you can't, for lack of time, draft a good complaint, but you certainly can draft a bad complaint. People who wait in the last minute usually have a talent for that sort of thing. So, serve a big, long complaint, even if it's not perfect. If you want advice on how to do a bad complaint, call me up. I have form books. And the irony being that if you serve a bad complaint and you can amend it, and your action is preserved in point of time, which was a little defective notice, you can't amend it. So that's the kind of thing you should stay away from. Except in collection cases, default cases, when you are expecting a default judgment, there it might be convenient just use a little 305B thing. All right, now here, number 11. Is that number 11 or is that number 12 now? Number 12. The court dismisses an action condemning this last-minutism and the use of a little 305B notice. You get to the end of the statute of limitations, and then, when you're right at the end, you take a chance in serving a little 305B thing instead of a summons and complaint. That's asking for trouble. They found it in this case. Number 13. Just an example of what satisfies as a 305B notice. It's so difficult to guess, and if you guess wrong, the consequence is so heavy. In this case, personal injury action for damages was all that was stated in the notice. The court sustained it. Boy, would I have been in a sweat if I had done something like that. This is purportedly a $3 million case. There's a little more attention and a little 305B 5 words on the last day of the statute of limitations. Absurd. Just absurd. They got away with it. Now, what do you take this for? This is a second department case. Is this an invitation to do likewise? Don't follow the invitation. Stay away from these things is the only thing I can suggest. Number 13. 14. Here's another one. Is there any such thing as a courthouse sanctuary? May you or may you not make service in the courtroom? That is the question. Have you ever made service in a courtroom?
No.
Have you ever been served in a courtroom? Do you specifically stay away from making service in the courtroom?
Yeah.
Might not be a bad idea. But is there any rule against it? This judge, a district court judge out in Suffolk or Nassau County, Suffolk, purports to find a courthouse sanctuary rule and voids the service. Here was the defendant in the courtroom. Why was the defendant in the courtroom? Contesting service in the first action. While he's there contesting service in the first action, the plaintiff has prepared new papers and serves him in the courtroom. The court voids it, dismisses the action. Courthouse sanctuary. Where did this thing come from, this courthouse sanctuary thing? I heard rumors about this over all the years. Only when this case came down did I look into it further. And I found a little footnote in a federal case that all the judge deemed it worthy of, a footnote. And it was great. He said, this court knows of no rule precluding service in the courthouse. I know of no such rule either. This court says that's the rule.